Greetings and welcome, crime enthusiasts. My name is Sigo. In a shocking turn of events, Dr. Nandipha Magudumana has been denied bail by the Bloemfontein Magistrates Court. Magistrate Estelle De Lange delivered the judgment, stating that Nandipha poses a flight risk, and no bail conditions would ensure her presence during the trial. Please like, share, subscribe and hit the bell button for more from Sigo's This and That. Your comments are also very important to us. This comes as Nandipha applied for bail for the first time since her arrest in April, where she was apprehended alongside her lover, Thabo Bester. Bester, a convicted rapist and murderer, had successfully faked his death at the Mangaung Correctional Centre and escaped in May last year. Now, Nandipha is accused of masterminding Bester's escape and has been charged with multiple offences, including fraud, corruption, and assisting an inmate to escape. This bail application falls under Schedule 5 offences, meaning the burden of proof lies with the defence to establish why Nandipha should be granted bail. However, the court found that she had access to the witness list, raising concerns about her potential influence on the case. Additionally, Nandipha's alleged central role in Bester's escape raises fears that she could attempt another breakout if released on bail, as Bester would be transported to and from court from prison. The magistrate emphasized that Nandipha and Bester had successfully evaded capture during their previous escape, suggesting their proficiency in eluding authorities. It is worth mentioning that Nandipha is not the only individual implicated in the Bester case. Others, including her biological father, and several G4S employees, have been granted bail. However, the trial against the group will be transferred to the High Court in Bloemfontein, and the proceedings are expected to span several months before reaching a conclusion. For 5 months, Nandipha has remained in custody, awaiting trial for her alleged involvement in the escape and other related charges. As the trial continues, the full extent of the shocking escape and Nandipha's alleged role as the mastermind behind it will be unveiled. Please continue to watch and listen to the summary of the judge's verdict.
Under B, we're dealing with the assets held by the applicant and where the assets are situated. The applicant does not own any fixed property. She owns movable assets to the value of R1 million. Movable assets can be disposed of with relative ease without her intervention. The evidence shows that she vacated the home where she lived before she left the country with accused number 5. We have no idea what happened to her furniture and her movable assets. Or rather, I do not have any idea. At this stage, she has no fixed address of her own, but accommodation was offered to her by a friend in Sandton. Under subsection C, the court takes into account the means and the travel documents held by the accused, which may enable her to leave the country. This is an interesting one. Her passport was confiscated by the authorities, so she doesn't have a passport anymore in her possession. But the evidence indicates that she does not really need a passport of her own to leave the borders of this country and to travel across borders, because this passport that was confiscated had no indication that she crossed any borders legally between March 2023 and April 2023, when she was arrested. But she crossed a few borders with accused number 5. It's a good indication that she has the necessary means, the know-how to leave the country. D, the extent, if any, to which the accused can afford to forfeit the amount of bail which may be set. At this stage, the real financial means of the applicant is not known to the court. Under E, the question whether the extradition of the accused would readily be effected should she flee across the borders of the Republic in an attempt to evade her trial. This is also a difficult one to answer, as we still do not know where the applicant and accused number 5 was heading to. The nature and gravity of the charge on which the applicant is to be charged. The applicant is facing many charges, which are of a serious nature. Most of them contains elements of dishonesty and deceit. The strength of the case against the applicant and the incentive that he or she may have in consequence to attempt to evade her trial is the next factor to be taken into account. The state's case is relatively strong against her. Chances of a conviction is good. The evidence is based on direct evidence, documentary evidence, other circumstantial evidence indicating she played a leading role in committing most of these offences. Under H, the nature and gravity of the punishment which is likely to be imposed should the accused be convicted of the charges against her. If she's convicted, she will most definitely be sentenced to a long period of direct imprisonment. But it is difficult to judge at this stage. It will depend on the trial court, and it will depend on the circumstances that will be placed before the trial court when they consider sentence. Under subsection I, the binding effect and enforceability of bail conditions which may be imposed and the ease with which such conditions could be breached, or any other factor which in the opinion of the court should be taken into account. If one looks at the evidence presented by the investigating officer and the number of people who were charged with the applicant, the positions that they held, their places of employment, one of them is even her biological father, one of them one of her employees. It appears that she and accused number 5 were able to convincingly deceive everyone to work with them. All these people risked their employment to assist in exchange for money which was not even paid to them after the escape was successfully carried through. It also appears that they could get through a few border posts successfully without using their passports, so it's possible that they managed to convince the authorities at the border post to let them through. I'm of the opinion that bail conditions will not be of assistance to get the applicant to stand her trial. If the applicant is released on bail, she will have more opportunities and means to once again attempt to assist Mr. Bester to escape. We must remember that this trial must still proceed, and it will be a lengthy trial. Mr. Bester will be transported to and from court for the duration of the trial. By allowing the applicant to go out on bail will enable her to yet again try to facilitate another escape if she wants to. If one looks at the evidence that the state has, the applicant was the main role player in facilitating the escape of accused number 5. If she's out on bail, nothing will stand in her way. She will have access to all the necessary information and people to facilitate another escape. Subsection C, where there's a likelihood that the accused, if he or she were released on bail, will attempt to influence or intimidate witnesses, conceal or destroy evidence. The court must here take into account the fact that the accused is familiar with the identity of the witnesses and the evidence which they may bring to her. The names of the witnesses were listed and made available in court to all the accused to whom bail was granted. The applicant does not have access to the witness statements yet, but she would know what many of them would be able to testify about. For example, she would know who she approached at the different mortuaries to claim bodies and so on. I'm also aware of a friend of hers who is a possible witness with regard to the passport that was handed over to the applicant under false pretenses. The court must also look at whether the witnesses already made statements and agreed to testify. From the evidence of the investigating officer, most of those statements have been obtained from the witnesses. Whether they agree to testify is not a question. Witnesses can be compelled to testify, even if they do not agree to testify, unless they may lawfully be excused from testifying, for example, if one of the witnesses are married to the applicant. Subsection C, whether the investigation against the accused has already been completed. The matter has been postponed to October for further investigation, so there is investigation outstanding. I'm not sure if it was concluded or not. At this stage, I must just say that each application for a postponement will be considered on its own merits, and if there is an unreasonable delay in the investigation, which is causing substantial prejudice to any party, I will deal with it in terms of Section 342A as required by the law. The court also takes into account the relationship of the accused with the various witnesses and the extent to which they could be influenced or intimidated, and how effective and enforceable bail conditions will be to prohibit communication between the accused and the witnesses. I'm unable to comment on this aspect. I have no idea if there are any witnesses who are related to the applicant, except for the one friend who handed the passport to the applicant under false pretenses. When we look at subsection F and G, whether the accused has access to evidentiary material and the ease with which evidentiary material could be concealed or destroyed, I cannot find any evidence that these factors are at risk. If one moves to subsection 4D, the court takes into account the following factors. Subsection 8A, the fact that the accused, knowing it to be false, supplied false information at the time of her arrest during the bail proceedings. I've already dealt with this. The applicant provided an address to the investigating officer in April 2023 when she was arrested, and the address was of a property that she already vacated during March 2023. At that stage, that was not her address anymore, but she gave it up as her address. The rest of the factors listed in this subsection is not applicable to the applicant. If one moves to subsection E, when exceptional circumstances, there is a likelihood that the release of the accused will disturb public order or undermine public peace or security. These will only be taken into account under exceptional circumstances. All I can say about this is that there are certain aspects that the applicant has been accused of which indeed has the potential to induce a sense of shock in the community. For example, the way in which the unidentified bodies of the deceased were disposed of. But the rest of this, I am not going to take any of those into account in making my decision. I'm of no way convinced that the release of the applicant would lead to public disorder. It could lead to shock, but this should in no way sway the court to refuse bail. There's no evidence before this court that the life of the applicant would be at risk if she is released on bail. And before the court makes a final decision, it is important for the court to take into account subsection 9. Subsection 9 deals with the weighing up of the interest of justice against the right of the accused to her personal freedom, and in particular the prejudice that she is likely to suffer if she is to be detained in custody. And here the court is also guided by certain factors. Subsection A deals with the period for which the accused has already been in custody since her arrest. At this stage, she is in custody for 5 months. Investigation is not completed yet. The probable period of detention until disposal and conclusion of the trial must be taken into account. I've already been informed that the matter will go to the High Court for trial in Bloemfontein. It is not possible for me to determine what time frame we are looking at. A trial date has not been arranged yet. If I look at the list of witnesses that were handed into court previously, the number of accused I can safely say that it will be a long, drawn-out trial which can take several months to reach a conclusion. The court must also look at the reason for any delay in disposal and conclusion of the trial and fault on the part of the accused. No one is to blame for the fact that the investigation is not complete. In complicated matters like these with so many charges, the investigation normally takes a very long time. It takes longer than usual to get all the loose ties together. Just like the defense will require sufficient time to prepare for trial, the state also requires sufficient time to get ready and prepare for trial. Financial loss the accused may suffer owing to her detention. That is one of the factors to be considered. The detention of a person who was employed or self-employed before arrest will almost always lead to financial loss. But in this particular case, it's important to remember that the applicant allegedly deserted her family and her business to leave with accused number 5. The applicant did not present any evidence to the court of the contrary, except for stating under oath in her affidavit that she was kidnapped by him. There is strong evidence by the state which is not supporting her allegation that accused number 5 kidnapped her. We also look at any impediment to the preparation of the accused defense or delay in obtaining legal representation which may be brought about by the detention of the accused and the state of health of the accused or the applicant. The applicant has obtained the services of an advocate, Advocate Lamini and Advocate Motlaung, to assist her during the bail application, and it appears that there was nothing preventing them from properly consulting with the applicant in order to proceed with this bail application. She also appears to be in good health. No allegation of ill health was ever brought to my attention. The court can also take any other factor into account which is, in the opinion of the court, relevant. I take into account that the applicant is detained in a correctional facility where she's taken well care of. Whenever she appeared before me, she appeared to be well groomed and in a good state of health. I'm confident that all her reasonable needs are met during her period of detention, awaiting trial. I never received a complaint from her regarding the circumstances under which she is being detained. I did, however, receive a complaint regarding her transportation to the court from the facility, but this aspect was addressed, and I accept it was suitably resolved because I did not receive any further complaints. As far as her children are concerned, they are with the biological father. It's always sad that children should be separated from their mother, but this is also a choice that was apparently exercised by the applicant when she left the country with accused number 5. When she left, she knew that she most probably will not return. Whenever she left under circumstances that she was kidnapped, whether that happened, that will come out during the trial. At this stage, all the evidence available points in the direction that she left voluntarily. She claimed in her affidavit that she was unaware of the presence of her passport and the other passport in the cubbyhole of the vehicle, but a witness filed a statement to the effect that the applicant deceived her in handing the passport to the applicant. The fact that they did not leave with one of the applicant's vehicles but in a rented vehicle, which they used to leave in the country, is also an indication that they intended to leave the country so that they would not be traced, to wipe out any trace of them. In conclusion, I find that the applicant is a definite flight risk and that no bail condition will assist under the circumstances to limit this risk. After weighing up the personal circumstances and the interest of the applicant and her constitutional right to freedom against the interest of justice, I find that she did not satisfy the court that it's in the interest of justice for her to be released on bail. It is, however, in the interest of justice that matters be tried and that a verdict be obtained in a court of law, and this can only happen if a person stands trial. Therefore, her application to be released on bail is refused.
Thanks for watching. Please like, share, subscribe, and hit that bell button. Bye bye.